Hi there. This is part 2 of a presentation about the Victorian Law Reform Commission. I'm Nick Gadd, the Communications Manager of the VLRC. We're going to look at an example of the VLRC's work. The VLRC's inquiries come from two sources. Many of our inquiries are given to us by the Attorney General of Victoria. The Attorney General can ask the VLRC to review any area of Victorian law. Community law reform projects are different. These are projects that the Commission chooses for itself, based on suggestions from members of the community. The Victorian Law Reform Commission Act 2000, Section 5, defines the functions of the VLRC. Subsection B refers to community law reform projects. The Act states that the Commission's role is to examine, report and make recommendations to the Attorney General on relatively minor legal issues of general community concern. We're going to look at one example of a community law reform project, Neighbourhood tree disputes, a project the Commission completed in 2019. This project was about disputes that arise between neighbours because of trees growing on private land. Members of the community told the Commission that the law was unclear and needed to be improved. So this project was responding to a problem in the community. Neighbours sometimes argue with each other about things like overhanging branches, roots that cause damage, and unsafe trees that create hazards. The problem is that the law in relation to these disputes is complex and hard to find. It's not always clear what people are required to do, and the processes for resolving these disputes are confusing and expensive. So, in June 2017, the Commission began an inquiry into neighbourhood tree disputes. The report was delivered to the Attorney General in July 2019. What is a tree dispute? Well, here are some examples. Often the disputes involve overhanging branches, which could hurt people or damage property, or roots, which can cause damage to paths or driveways or foundations. Here are some other problems that trees can cause. Sometimes neighbours argue about whose responsibility it is to do something about the tree. There have even been cases of neighbours taking the law into their own hands and damaging their neighbours' trees with poison or chainsaws, or trespassing on their land. So sometimes these matters, which may seem quite minor, can actually escalate into criminal conduct. The Commission published a consultation paper in December 2017, explaining what the law is now, what the problems are with it, and also including a number of questions for the community to respond to. The Commission held consultations with people in metropolitan and regional areas to find out their views, also including arborists. And 124 people responded to an online survey. The Commission received 38 formal written submissions. The community told the Commission that tree disputes are common and can have a serious negative effect on people's lives and their enjoyment of their home. There is no single Act of Parliament in Victoria that sets out the law of tree disputes. There is only the common law, that is, a lot of different decisions by courts, and a patchwork of different local laws, and other laws to do with environment, heritage, and planning. This makes the issue complex and confusing for people. It's difficult for people to know what the law says, and they don't know how to resolve a dispute if it can't be solved by informal discussion between neighbours or by mediation. In that case, the only option is to go to court, and that is very expensive. It's stressful and the outcome is uncertain. The Commission concluded that the community needs clearer laws and a better way to resolve tree disputes. The key recommendation was a new act is needed, to be called the Neighbourhood Tree Disputes Act, so that the law about this matter is all found in one place. This act should help the community to resolve their disputes cheaply, quickly and effectively. The Commission recommended that the new Act should encourage people to resolve their disputes informally with their neighbours. Community education should be provided about how the new Act works. A new website should be created so that laws and information are easy to find. When disputes can't be settled informally, the Victorian Civil and Administrative Tribunal, VCAT, should make decisions about disputes, with the help of experts such as arborists. Going to VCAT is much less expensive and easier than going to court. The Act should provide clear principles to assist VCAT to make its decisions and to guide the community about the application of the law. The new Act should also provide for a range of practical and effective remedies for tree disputes. The Commission's report included 63 recommendations in total. You can find them all at the VLRC website. The report was delivered to the Attorney-General in July and tabled in November 2019 in Parliament. The Attorney-General announced that the government intended to implement all the recommendations at a time to be decided. At the time of making this presentation, the law has not changed. To learn more about the VLRC, we recommend that you check out our website, where you will find much more information about all our inquiries. You can also follow us on social media and listen to our podcasts, including one on tree disputes. If you have specific questions that are not answered on the website, feel free to email us. Good luck with legal studies.